Hello, once more welcome to the Law Professor channel. In today's presentation, we shall be looking at the second element of the tort of defamation, reference to the plaintiff. What do we mean by a defamatory statement referring to a plaintiff? We need this aspect of the tort because if a statement does not refer to you, then that statement cannot be defamatory of you. And it's quite simple in most cases to know if a statement refers to a person. Okay, but there are some situations that will require some deeper interrogation as to the person that a defendant was referring to in a statement. We'll proceed to share our screen. Okay, so okay, here we are. So in the presentation of today, like I said, what does it really mean when we say that a defamatory statement must refer to the plaintiff? Now, what we are seeing is that the statement that you are complaining about, the set of affairs that you're complaining about, may refer to the plaintiff by mentioning that person's name. Mr. AYZ can mention the name of that person directly. It might give a description that everyone would know that this is the person you are talking about. If you say, oh, the current president of Nigeria, for instance, there's only one current president of Nigeria. Or if you give a description that it is quite clear to anybody listening or seeing the statement that this is the person you are describing. It might be by inference. You know, we talked about defamatory statement. I said it could be written oral. It could be a picture, it could be a cartoon, anything that any reasonable person could say is referring to the plaintiff. So in most cases, it's quite easy to know that this statement refers or is referring to the plaintiff. One of the things we must know about this tort is that it is only actionable at the suit of a living person. Only a living person can sue. You cannot defame the dead. It's neither a tort nor a crime to defame the dead. And the reason is that defamation as a tort is a right in the right of action in defamation is a right in persona. It is a personal right of action that can only be exercised by the original parties to the suit. So once either party is dead, the cause of action is gone. It's gone. It is a personal right of action that can be only exercised against a particular defendant by a particular plaintiff. However, if the defamatory matter is such that casts aspersions on the relations of the dead person, then the relations may sue. So you need to look at the context of the defamatory statement to determine if they would have a cause of action. So in terms of reference to plaintiff, like I said, in most cases, it's quite clear when you say Mr. AYZ is a thief. He was caught embezzling money in his office. He was caught doing something or the other. It's quite easy to say, okay, that person is very referred to. Sometimes you have situations where someone has written an article, a book, a story, or a TV series or something that they just used a fictitious name. And unfortunately, someone happens to have that same name. And in most cases, when you have a work of fiction, it is normal and safe to put a disclaimer to say this is a complete work of fiction and the names and character are fictitious and do not refer to any person that is living. But if it so happens that you use a fictitious name, and that was what happened in the case of Holton against Jones, and the storyline is believed by the society to refer to a person with the same name, then it will be defamatory. And the usual remedy is to publish a retraction to say that this is not meant to refer to a particular person. But the general rule is that that person who has the same name with the fictitious name actually has a cause of action in defamation. Then you have a situation where two people have the same name. You write a story, like the case of Newstead against London Express newspaper, where the story by the newspaper was in relation to Mr. Newstead, who was real and the story was true. But unfortunately, there was another Harold Newstead, again, 30-year-old man. You know, descriptions were almost like the same. And people that knew the plaintiff Newstead thought the storyline was referring to him, and he sued. So these are some of the situations where issues about reference to the plaintiff may be raised in an exam. The question may relate to somebody using a fictitious name or two people with the same name. And in that case also, that plaintiff will have a cause of action. But of course, in practice, once it has been brought to the attention of the defendants, the ideal thing is to publish. Also, in the same platform, a retraction to the effect that your attention has been brought to the fact that there's another Newstead, for instance, and it is not meant to refer to that particular person and what have you. So offer of amends is that kind of a defense. And if that is done, even if the person decides to sue, they cannot really get any significant compensatory damages. So when you have situations like this, they are called intentional defamation. And if you look at defamation law of most states in Nigeria, for instance, legal state, it has a legal framework for how you treat unintentional or innocent defamation. You make an offer of amends. Then you have situations, still under reference to the plaintiff, where you have class or group defamation. This is also quite common. For instance, I'm sure you have had statements like, lawyers are liars. People make that statement a lot. You know, they say nurses are promiscuous. There are some generalizations that people make. Now, if statements like these statements are made, it is not possible for any lawyer to just go to court and say, I have been defamed. This is what we call class or defamation. Or you say Nigerians, if you say Nigerians are dishonest, or you say Unilag students, Unilag students are lazy, or UI students they are not committed to studies. You know, general statements. These ones I even gave are actually statements of opinion. But if you just make statements that are general about a group of people, no individual member of that, as a general rule, can bring an action for defamation. Okay? But in order to treat group or class defamation, in the case of Norfolk against London Express newspaper, the House of Lords laid some guidelines down as to how you treat class or group defamation. And that you should ask yourself some questions. Number one, of course, as the general rule is applicable, if what were published about the plaintiff, particular plaintiff, you could sue like a normal individual. But for the group defamation, no individual member can sue. Then the court said that if the statement points to a particular plaintiff, even though it seems like you are making a class of defamation, but if there is clear evidence that this statement is pointing to this particular plaintiff, and those who know the plaintiff would know that you're actually referring to him, then the plaintiff will be able to sue. So if looking at the statement, anybody can reasonably infer that what you are saying, even though it appears to be like you are saying all lawyers are liars, but they would see that you are referring to a particular plaintiff. Maybe in the course of making that statement, you have referred to this plaintiff, Mr. XYZ, is corrupt. He has stolen clients' money. He has commingled clients' money. He's corrupt, just like all lawyers are corrupt. In that context, Mr. XYZ, or whoever he is, would have a cause of action, because it will be clear to everybody that even though you seem to be making a class or group defamation, it refers to the plaintiff, to Mr. XYZ. If the reference is to a small group, it may be referring to a group of people. But if the group is such a small number that it is possible to identify every member of the group, it is possible to identify every member of the group, then in that context, each member of the group would have a cause of action in defamation. So, of course, in the first of each case, we determine whether this group is small enough or, to constitute identifiable individuals. Or if the group is small, each member of the group may be able to bring an action. The corporate bodies, you know that corporate bodies have legal personality, just like we human beings have legal personality. Now, defamation as a thought, like we established earlier, protects reputation, what people think about you. The rule regarding corporate entities, for instance, you say, oh, XYZ company conducts its business in a fraudulent way. It's not paying, they're not paying their taxes, it's not paying the workers, it's treating the workers in a way that's contrary to the rights of workers. You know, we make those statements. Can the corporate entities sue for defamation? Now, the law is that a corporate body may be defamed, but it cannot have its feelings injured. And defamation is about feelings. Defamation, what people think about you, what they say about your reputation, the ideology, the conception that people have regarding you, your behavioral patterns. Now, a corporate body may not have feelings, but it may be injured in its reputation and goodwill. Corporate bodies have goodwill. They have the attractive force that the driving force that attracts business onto them. They have that. And sometimes people relate and buy their goods and interact with their services because of their goodwill. Some of you buy a bag because of the name of the maker, you buy your cars, you know, you interact with entities. Even something as little as buying a piece of bread, you have the ones that you would buy. That is because you know that they have a reputation, they have a goodwill. And that is why you are sure that if I take this, I'm sure it's going to last or it's going to be good. So that is their goodwill, that is their reputation. That is what attracts customers to that particular business. So it can be injured in its reputation or goodwill. So it cannot be injured in its feelings. You see that established in Basi, Edom and other against Ophio Nigeria Limited. You see Louis and Daily Telegraph newspaper, where the court said a company cannot be injured in its feelings. It can only be injured in its pockets. Its reputation can be injured by a libel, but that libel must sound in money. It must result in loss of money. The injury need not necessarily be confined to loss of income, and the goodwill may be injured. Goodwill is expensive. It is not acquired, you know, overnight. So the libel that you are talking about regarding the corporate entity must sound in money. So if it results in damage to the trading reputation and interest or property, and how do you assess that? You would see that maybe people would refuse to interact with it, to buy its goods and services, you know. So those are the reasons, those are the ways in which a corporate entity may be able to bring an action in defamation. A government body cannot sue for defamation. Lagos state government, federal government, the House of Assembly, the Ministry of Health, Central Bank, government entities cannot sue. You can see Awoni against registered trustees of registration order, and the case of Omega Bank PLC against state government and another. The common law rule against corporate entity suing is because, look, the law guarantees freedom of expression for the citizens. Government entities are operating with taxpayers' money. They are agents of the people, okay? And as an organ of government, if an organ of government is going to sue, it's going to use public funds to prosecute the case. You cannot be suing the public with its own money. If I can put it as bluntly as that. You cannot be suing or be the government, the society, the people that are paying tax, using their money to sue them. So if a government entity is going to sue, if the government of Lagos State is going to sue a citizen of Lagos State, or for instance, it's going to be suing the state funds. That citizen is paying tax. So, and the law guarantees freedom of expression. So for this reason, it is said that common law, and without reference to the guarantee of freedom of expression in Act 10 of the European Convention on Human Rights, an organ of a local government may not bring an action on defamation. The same thing was repeated in Awoni against registered trustees of prosecution order. The Omega Bank PLC and the state government case also said that in defamation is both a private and personal matter, because you are talking about the reputation of a person. And the court said that it is my opinion from a moral and policy perspective. So if you are asked, for instance, on what basis is it that the law says that government entity cannot sue for defamation? it is morally incorrect, and there are policy reasons why you should not allow government agencies to sue for defamation the agency, the government body as an entity. I'm not talking about the individuals. So public officers have no right to sue and be sued for libel. It will be against public interest, public policy, moral connotations for government officers to use tax paid by the people to institute actions against them for libel. If the right of action is granted to government officers to maintain action for libel, the constitutionally guaranteed freedom of expression will be curtailed. If the attack on the government body defames the individual member of that body, the office holders, okay, that person can sue in their private capacity using their personal funds, but he cannot sue, for instance, as Minister of State, Minister of Education, Minister of Governor of Edo State, and whatever, and you are seeing that the governor, has been defamed. No, it is only in the personal capacity where the defamation reaches their personal capacity that they can sue. And you see this being repeated also in the South African case. Now, politicians and political parties, a politician can sue. I'm not talking about a public office holder now, government. I'm talking about the individual politician. If the statement that the defendant has made reflects on the reputation of that politician. Again, that case of Omega Bank versus the state government will give you a clear understanding of the principles in this area. Okay, where the governor, Governor Fayose, was suing as governor of Ekiti State, and the court said he should have sued in his personal capacity for the thought of defamation. Political parties cannot sue, but where an individual member of the party is defamed, that person may sue. Trade unions also cannot sue. So in conclusion, therefore, when we talk about defamatory matter, a statement referring to the plaintiff, it means that it may mention the person by name, it may mention the person by description, it may refer to the person by description, there may be an inference in any way that you can see that this person, what the person is saying is defamatory, then the person will say this statement refers to me and I want to bring the cause of action. The person that must bring defamation is a right, as a cause of action is a right in personal. It's not a right in rem. So only a living person can be defamed, not a dead person. Even if the case had started at the beginning of, and then one of them dies, that is the end of the matter. It's only in situations where defamation of a dead person casts aspersions on the relatives or on the living relatives that those relatives may bring a cause of action. Business entities, corporate bodies can sue to protect their business or trading interest. And government bodies cannot sue. Politicians can sue in the personal capacity, but not as a government body. Okay. Trade unions say cannot sue. So corporate entities can sue for reputational damage. Cannot sue for reputational damage. They have no feelings that you want to protect, but they can sue for injury to their pockets. So essentially, those are the major contents and issues when we talk about a defamatory matter referring to the plaintiff. Other issues may also arise in the course of practice, but the essence is that the law will try the court will try as much as possible to ensure that the person that is before the court is the person that has been defamed. And if this is established, then that second element of defamation would have been established. The first element we said that the person has made a defamatory statement. So the second element is that the statement must refer to the plaintiff. Okay. Now the next video we'll be looking at the fact that statement must be published. It must be published. Once it's published, it is not defamation. So I'll see you at the next presentation. Don't forget to subscribe to this channel, to like the video, and to share with other students and practitioners and anyone who actually intends to have a knowledge of the law. So to be a part of this channel.